Hello and welcome to Topic 11, Lecture 2. And in this lecture, we're going to be taking a look at the death penalty. All right, so what are we going to be covering in this lecture? Well, first, we're going to look at the trends in the use of the death penalty. Next, we're going to look at what the Supreme Court has said about the constitutionality of the use of the death penalty. And then we're going to end with doing an overview of this week's discussion of the movie that you're going to be watching, Dead Man Walking. So that's what we've got on the docket. Should be a relatively short lecture, so let's get started. So it almost goes without saying that the most severe sentence that you can receive in the United States is capital punishment. And the United States is an outlier in terms of nations using capital punishment or the death penalty for a punishment for a crime. More than 70% of the world's countries have abolished capital punishment in law or in practice. Today, 27 states have the death penalty. So, more than a majority of the states have that as a legal punishment. That also includes the federal government. The federal government uses the death penalty as a potential sentence for a federal crime. So 27 states have the death penalty, 23 states do not, and Wisconsin, as you know, does not use the death penalty as a sentence. And this is a map that shows the breakdown of the use of the death penalty in states in the United States, as well as the federal government, and this comes from the Death Penalty Information Center. And so you can see here that the states that are in red, these are the states that use the death penalty. The states that are in yellow, including Wisconsin, are states that do not use the death penalty. And then states like California, here, these states in orange, those are the states that have a governor placed moratorium on the use of the death penalty. So in those states, legally, that the death penalty is still on the books, but that the executive of the state, the governor, has basically said that the death penalty cannot be used. Oftentimes, that can be a precursor to the state abolishing the use of the death penalty within their states. And then here on the side is for federal law that an individual can be sentenced to death for the violation of certain federal law. And so on this side, it's showing basically the diminished sentence of death that we've seen historically in the United States. Okay. And so, these aren't the number of executions to take place, but this is the number of people who have been sentenced to death. And it starts in 1973, and we'll talk about why that is in a moment, okay? Because that date has some significance. And you see from 1973 moving forward, we see an increase in the use of the sentencing of death in the United States, with a height around 1999 to 2000. And since there, we see a real diminishment of the sentence of death in the United States. So we're definitely seeing a downward trend in the United States for even states that obviously use the death penalty. States, we see that even though you can use the death penalty, that individuals are not receiving that sentence with great as frequency as they had done, within the 20th century. And this is a slide that shows the number of executions in the United States from 1977, which again will be an important date that we'll talk about in a moment, and then to where we are, the latest data from 2021. And we see a very similar trend, right? A rise in the use of execution as a punishment, and then just as we have with the sentencing, a diminished use of execution as well. And, just a couple of things to notice. I mean, that, the highest in the United States that in terms of the number of executions is less than 100. So it's still really rarely used. And in, the last several years, less than 20 people are executed within the United States. You're going to see a rise here because keep in mind that kind of reflects the rise of violent crime in the United States and this get tough on crime sort of mentality And so that's going to be coupled with the severity of sentences as well, including the death penalty. One of the questions that comes up as it relates to the use of the death penalty is whether or not the death penalty is constitutional. Or in other words, does the Eighth Amendment prohibit the use of the death penalty because the Eighth Amendment prohibits the use of cruel and unusual punishments? Since the court has started, hearing cases about the constitutionality of the death penalty, they've been consistent in ruling that the death penalty is inherently neither cruel nor unusual. In other words, it does not violate the Eighth Amendment. However, what the court has said is that in certain circumstances, the death penalty can be unconstitutional. And that is what brings us to that date of 1973. Because in the United States, there have always been people who feel that the death penalty is inherently cruel and unusual punishment, that it is inherently a violation of the Eighth Amendment. And so interest groups that are anti-death penalty interest groups will often bring cases to the Supreme Court to get the answer, to raise the question about whether or not the death penalty is constitutional. And so that happened in 1973. And so in 1973, the name of the case is Furman v. Georgia. You'll read a little bit about it in your textbook. This case came to the Supreme Court, and the argument was made that the individual in this case got the death penalty. And the argument was made that sentence was in fact a violation of the Eighth Amendment. And in Furman v. Georgia, the Supreme Court agrees and says that how the way that the death penalty was currently used in 1973, they felt that it was in fact cruel and unusual punishment. Some of the things that the court took into consideration was that there was evidence about that the racial bias was present in the use of the death penalty. In other words, that Black people were more likely to receive the death sentence for a similar crime than a white person. And so, for example, the evidence that was presented in Furman v. Georgia basically, showed that an individual who's most likely to get the death penalty is a Black person who kills a white person. And the individual who is least likely to get the death penalty is a white person who kills a Black person. And so the Supreme Court said that given sort of the presence of racial bias in the sentencing of people to death, as well as sort of an arbitrary imposition of the death penalty. So in some states, you could get the death penalty for a non-homicidal case, right? For rape or for abuse of a child. In other cases, not so much. I mean, that it had to be a homicide. So since there seemed to be an arbitrary imposition of the death penalty, the Supreme Court said, as it stands in 1973, that the way the death penalty is used, it is unconstitutional. And so the decision in Furman v. Georgia basically places a hold, a stop, or a moratorium on the use of the death penalty, right? And so that's why that those graphs start at 1973 and in 1977, as we'll see in a moment, because there was a moratorium from 1973 until 1977 on the use of the death penalty in the United States. However, in Furman v. Georgia, the majority of the court did not rule that in and of itself that the death penalty was inherently cruel and unusual. They basically said that with changes that the death penalty could be used, with changes that having to do with racial bias and having to do with arbitrary imposition of the sentence, that they said if those problems were addressed, then the death penalty could be reinstated and be deemed constitutional by the court. Okay, so in 1973, the Supreme Court rules that as it is currently used, the death penalty is unconstitutional, that it violates the Eighth Amendment. The question is the court says that with changes, then that the death penalty could be used again, that it could be used in such a way that it doesn't violate the Eighth Amendment. And so states went back to their laws, and they basically looked at their laws and figured their laws based on the complaints that the court had in Furman. And that's exactly what Georgia did. So Furman v. Georgia, Georgia looks at its state laws and changes its state laws to correspond with the concerns that the Supreme Court had. And so in the case Gregg v. Georgia, a case where another individual receives the death penalty, comes to the court in 1976. The Supreme Court does that it limited the use of the death penalty to certain sorts of crimes and with certain sorts of changes that were implemented into state law. And so basically in 1977, and we saw that date on the slides, that states, if they made these changes as outlined in Gregg v. Georgia, then the state laws would correspond with the demands of the Eighth Amendment. And so that basically the Supreme Court said that the death penalty can only be used in certain kinds of crimes, crimes that have multiple killings, homicides in the course of the commission of another felony, shooting of police officers, etc. And so the death penalty, or the court kind of identified certain types of crimes that can constitutionally be subject to the death penalty. They also said that Georgia had made changes to its system of sentencing people to the death penalty, and that what Georgia instituted was a two-step process for the sentencing of someone to death. So, and the court said that this was a good practice and that it's one that's implemented in states that use the death penalty. So there are two phases. That the first phase is the verdict phase. And so the question comes to the jury, is this person guilty of the crime or not? And so there's the first phase is just about determining guilt. If the person is deemed guilty, then there's a second phase. And the second phase is the sentencing phase. And it's in that where it's at that moment that the person who is found guilty, the jury decides whether or not they will receive the death penalty. So you'll remember back to the first lecture when I said usually the jury doesn't play a role in sentencing. In death penalties, it does. And so that you have the jury who determines basically whether or not this individual will receive the death penalty. So with those changes, the Supreme Court said that the death penalty could be reinstated, and it was no longer a violation of the Eighth Amendment. Now, and so as it says there, with changes, the court ruled that the death penalty is constitutional. Now, since Gregg, that the Supreme Court has heard additional death penalty cases, and they will continue to hear those in the future. And so they have found some additional limitations on the constitutional use of the death penalty. One limitation is that if somebody suffers from a mental disease or defect at the time of the commission of their crime, or if they suffer from mental retardation, then they cannot be executed. So people with diminished intellectual capacities or who are mentally ill cannot be subject to the death penalty. Furthermore, the death penalty cannot be used for a capital offense that was committed before the age of 18. Even if the individual is in fact 18 at the time of execution, if they committed the capital offense prior to the age of 18, they cannot be subject to the death penalty. And so those are some of the most recent limitations that the Supreme Court has placed on the use of the death penalty. Now, given the conservative makeup of the Supreme Court, I highly doubt that, at least in my lifetime, probably in your lifetime too, but who knows, I highly doubt that the Supreme Court will ever find the death penalty unconstitutional. Basically, in the 1940s, when they started ruling on these cases, they said that they looked at the intent of the framers, those who wrote the Constitution and the Bill of Rights, and they said that the use of the death penalty was used at the time period, at the time when the Constitution was written. And so they basically said that why would the framers include a cruel and unusual provision if the death penalty was actually being used at the time? Clearly, if the death penalty was being used, then the cruel and unusual provision of the Eighth Amendment is not referring to the death penalty. It's referring to something that Not that the death penalty can't be cruel and unusual, but that inherently the death penalty isn't cruel and unusual since it was in use at the time. Furthermore, the court has said that the due process clause in both the Fifth Amendment and the 14th Amendment that says that somebody's life cannot be taken away without the due process of law, again, that's why the court has found it to not be inherently cruel or unusual, because if due process is followed, your life can be taken away by the state. Okay, I may be wrong. It may change in the future, but if I were to be a betting person, I would say that it's unlikely that the Supreme Court will find the death penalty to be inherently cruel and unusual in violation of the Eighth. Okay, so this week you're going to be having an online discussion about the death penalty. And to do that, there's a couple of things you need to do to prepare for the discussion. One thing is that, as it says there's in the book on pages 447 to 457, that there are arguments that are like a summary of the arguments that are used in favor of the death penalty, and a summary of the arguments that are used against the death penalty. And so read those. That'll be a part of the discussion. You'll be asked to weigh in on which do you think are the most compelling arguments for and against. But the main part of the debate is a discussion of this outstanding movie called Dead Man Walking. As it says there, that Dead Man Walking is a book that's based on a true story. It's written by Sister Helen Prejean. She's a Catholic nun, and she was asked to serve as the spiritual counselor for an individual who was who was on death row. And while the person in the book, the real life person's name isn't Matthew Poncelet, it's based on another person, but it captures what her experience was. This movie is about Sister Helen Prejean, played by Susan Sarandon, and Matthew Poncelet, who is played by Sean Penn, and who's convicted of a really gruesome murder. And so you'll watch the movie. It's an excellent movie to watch. The reason I have you watch it is not only because it's a great movie, but also I've seen this movie many times, and every time I watch it, part of me thinks it's a pro death penalty movie. And another part of me thinks that it's an anti-death penalty movie. There are cases to be made that you really get sort of a full picture of the complexities that surround the use of the death penalty. It also has some excellent acting performances, and you will see in the discussion itself, there's a little trailer that you can watch before watching the movie. Do keep in mind that there are some violent scenes in the movie. But it is, in my opinion, handled very tastefully. It is not gratuitously violent. And so that's the discussion for the week. This is like maybe the shortest lecture for all semester. I really look forward to reading your discussions, and I think you will really enjoy watching the movie. Thanks for paying attention. I appreciate it, and I'll talk to you again soon.